1st at 2 o'clock. That can be by Zoom as well. How long have you been in treatment?
Since November, Your Honor.
Okay, are you in transitional right now?
I was in transitional. I'm in Bridges for restabilization.
Oh, that's right, I forgot, yeah, okay. All right. And we want to miss with, I went ahead and started without you because she's in the treatment facility, so, but I've appointed you to represent her and enter the non-guilty plea on her behalf.
Okay, thank you.
So the first pre-trial is May 18th at 2 o'clock, and final pre-trial is June the 1st at 2 o'clock, both of those by Zoom. And the trial date will be June the 16th, 8 a.m. Bond will be OR only. That's your promise to appear. And if you fail to appear, you could be prosecuted for an additional felony. And the conditions of your bond are that you're going to comply with your treatment program at the recovery counselor or at the counseling center and aftercare and drug court conditions. Okay, your attorney will be able to talk to you later tonight, and your first pre-trial will be on the 18th of May by Zoom. And make sure you keep in touch with her. And you have your attorney's phone number or email.
I don't, but I can probably do what.
Well, go ahead and give it to her there with you, Ms. West, if you need that.
Okay. 937. All right. 393. Okay. 3487. Okay. And just leave it, if I'm not in, just be sure to leave a good number. I can call you back. Okay. Okay. Thank you.
Thank you. Once you text the jail, tell them we're ready. You go ahead and sign off, Ms. Purcell.
Okay. Thank you.
Tell them we're ready to do the 9 and 9:30 cases. Ms. Collins, you get the message that we're going to do a couple of Bill Armstrong's cases here after the 9:30?
Yes, Ms. Williams let me know yesterday.
All right. Do they know this is my Zoom and not video?
Hey, Lieutenant, we're ready for the Zooms. Okay. All right, good luck. Bye. They're having internet issues, Judge. Lieutenant Brown said they're doing the best they can.
Internet issue.
Apparently, they got internet in the whole building except for the little room where they do Zoom.
Say what now?
They've got internet in their building except for in the little room where they do Zoom.
Yeah, so, and that's Wi-Fi, I think, in that room. detail. All right, are you Dusty Allen Taylor?
Yes, sir.
All right, this is case number 22 CR 48. State of Ohio versus Dusty Allen Taylor. This hearing being conducted by Judge. It's a pretrial. Mr. Taylor is appearing from Star. His attorney is Captain Hacker, appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. The defendant was indicted for breaking and entering theft, 2 counts of theft. This is a first pretrial. Final pretrial set for assumed by week of May 16th to be determined, and then trial set for June 13th. See that the state provided discovery on the 14th, and the victims on the 18th, and you received those this afternoon.
I did.
All right, and you have not yet filed your discovery, so.
I thought it yesterday afternoon.
Oh, okay. All right. I haven't seen it yet. You just made any pre-trial motions?
Not at this time.
All right. Has there been any written plea offer provided?
Yes, Your Honor.
I have not received a written plea offer.
It was put in your box on April 18th with the discovery, with the bill of particulars.
I had 3 cases. I got discovery on Walker, Skeet, and Taylor, and all of them had discovery. I had no particulars, but I did not have any plea forms or any plea offers.
Hey, Adam?
Just get him another. Just send one over. All right. Okay. So anything else that we need to discuss at this point? All right, not. Mr. Taylor, how long have you been at Star?
Almost 2 months.
2 months. All right. So you're still scheduled to be there for about another month or so.
Yeah, I probably close to 2 more months left.
All right. All right. So we'll have this case probably completed in right about the same time. All right. Okay. We'll go ahead and get another pretrial set up then in another month or so. I think week the 16th. I think it said, and we should know more than that. All right. Thank you, everyone. All right. Ms. Hapner, the jail can't get online, and so I ordered them to bring everybody up to the courthouse. So you'll need to come over here for your other hearings. So I'm going to do Ms. Witt first so she can get to Adams County as soon as they get here. It is case number 21-0149, State of Ohio versus Chad Burgess. Principal states, prosecuting attorney Collins, present on behalf of defense attorney Daniel Witt. You are Chad Burgess.
Yes, sir.
And Mr. Burgess enters guilty to aggravated possession of a 1773 felony. I will refer to the probation department for pre-sentence report, which I have received and reviewed, and each of the attorneys received a summary.
Yes, Your Honor. Yes, Your Honor.
All right, Ms. Collins, anything on behalf of the state?
Only what's contained within the plea agreement.
Ms. Witt?
Yes, Your Honor. We asked the court for residential treatment for Chad. While he was, I think, released from Brown County, after talking to him, I don't believe that he had any malicious intent in not reporting to probation in those 2 weeks. He was hospitalized briefly during that as well. He's expressed to me that he does want treatment. He does want to break away from this area, so there is a bed available at the Recovery Council tomorrow. So we just asked the court for that.
What was the case you had down in Brown County child support? Is that a contempt case?
No, they sent the letter to the wrong address, but I gave you the right
No,
address.
I'm saying, were you in there through the domestic relations court, child support hearing, or was it a criminal case?
Juvenile.
Pardon me?
Juvenile.
Juvenile?
Yeah.
Okay. Lieutenant Brown, I don't know how he got out of our jail, because for civil contempt and domestic relations, they can't remove him. And even if they had, they should have brought him back. But, so what I'm going to do, you're still in charge of jail?
Actually, Hunter and Charlie go in.
All right, well, we're going to have a meeting to discuss that, because in the future, they're going to be taking, Brown County's not going to be taking it out of our jail without my approval, and with the hold on that they'll be returned, because he should have been returned. So it's not his fault.
There was a order placed on him. Why Brown County released him, I do not know, but.
Well, no, I mean, we had custody of him. When they take a warrant to remove, they're borrowing him, and they're returning to us. And they just returned him with, so they apparently don't understand that, so I'm just gonna make sure there's an order on this court that nobody goes to Brown County in our custody without my approval. Now, that being said, why didn't you come back and report to the jail, the probation department?
I have him on call at the courthouse and they told me just.
In other words, you got no excuse because you just had freedom and you didn't think you needed to come back.
Actually,
You were supposed to be in custody. So basically what they did, you should have called up the probation department, your attorney or somebody and said, hey, I don't know what I'm supposed to do, because I'm in jail, I'm not supposed to be free, they're letting you loose. Now, I understand Brown County screwed up royally, and we're gonna make sure they don't screw us over again. But here's the thing, you didn't do anything to come back and talk to anybody, and, that doesn't look good. Now, that being said, I'm gonna give you a break on this, but I also noted in the PSI, and you were asked about, this offense, and, you had, one of the all-time dumb comments that I've read. Everybody messes up every now and then. Well, that kind of an attitude, you're going to end up going to prison. So you need to understand right now that this is a chance for you to change your attitude. But if your attitude ain't going to change, then your course future course is going to, and that means so you're put on probation for community control for a period of 3 years. Under these conditions, you're to obey all laws, all jurisdictions, conduct yourself in all quiet manner at all times, report when and as directed. You keep your supervising officer informed of your residence, place, and employment at all times, may not change either without prior permission. May not leave the state of Ohio at any time without prior written permission. May not enter upon the grounds of any correctional facility, nor may communicate with or attempt to communicate with anyone who's inmate in any of those facilities without prior permission. Written permission of your supervising officer. Now, because of your conviction, you are not permitted under either federal or state law to possess, own, use, or have under control any type of firearm, ammunition, dangerous ordnance, or weapon of any kind. And if you do so, you can be prosecuted for that, and convicted and sentenced in both federal and state court for a felony. It's also a condition that you not have any of those items like under control. Not permitted to purchase, possess, use, have under control any kind of controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has effects similar to those, nor any instrument, device, or thing that may be used to administer them or prepare them for administration with check law prescription. You must provide a copy of that within 24 hours of receipt. You're to submit to drug testing when and as requested by the probation department. You may not purchase, possess, use, or have under control any alcoholic beverage, or may be present in places where the soul being consumed because otherwise law. You're not to associate with anyone who's a co-defendant in this case or any other person that's a criminal record, member of a gang or a criminal group, or any person who has a past in the future. Unless you commit a criminal offense and violate these conditions, thus approved right by a supervised officer that also applies to family members, doesn't know you were presiding with legally prior to commission of this offense. After the date of this order, not permitted to marry or establish cohabitation or common law marriage type relationship with another person after commission. You must report any charge, any contact with law enforcement, any arrest, citation, conviction, or other charge violating the law not made of the next business day after that occurs. You are to provide financial officer or your supervised officer financial information so your ability to obtain fees or costs will be reviewed. You're referred by the probation department for any further assessment, evaluation, for the type of treatment, training, or programming, or that any program recommended with the role is successfully completed that program. You're paid court costs of this action. When you came ready to do that, you'll be required to do 4 hours of community service, rate 20 hours a week, only consecutive weeks, unless you're employed at 20 hours a week. Sometimes you have documentation of prior disability finding or a letter from the doctor participating in performance services. Maybe jail until you're conveyed to a bed at the Recovery Counseling Center. Understanding there's a bed available tomorrow, we're going to have confirmation that you have or a written confirmation, but I did receive oral confirmation through your attorney. And so we will be required to successfully complete substance use disorder treatment at the Recovery Council and recommended aftercare. Now, by being placed on community control rather than being sent to prison or being sent to a search of a person, your residence will be without you or either ready to properly place under control where you're found at any time any officer of the commission department. Be no fine or driving suspension imposed. Court costs are also ordered as a substitute order. If you fail to pay, maintain arrangements to pay those costs, and the clerk will take that regression, including letting the bank accounts later for the rest of the assets you may have. That doesn't reflect it then upon completion of your then the court can order you to service in addition to what I've already ordered, and you'll be given credit for each hour work in an hourly rate set by the court each hour work for which you've got by that amount in full. Now, Mr. Burgess, in the event that you fail to comply, I can tell you right now, you better complete the substance abuse program. It's not a lockdown facility, and if you try to leave, they're not going to attack you. But if you leave, then you better make sure you don't ever get caught, because if you come back here, that's going to be a one-way ticket for us to Oregon. And we're not going to put up with it because you've already pulled one son, but it's not coming back, and that's not going to happen yet. Now, if that occurs, then the probation department will file written notice of that. There'll be a hearing, and the outcome of the hearing is that you fail to comply, then the court will impose a sentence upon you. The minimum will be 6 months, it'll be 12 months if that happens, and a fine of $2,500. If that happens, then once you complete that felony sentence, the APA is authorized to push you under post-release control for a period of up to 2 years, and the duty will be supervised and permanently set. And if you violate those conditions, they can return you to prison, they can serve additional period up to 1/2 of the prison term that's been ordered by the court. If you commit a felony, in addition to sentence judgment, in case you impose that offense, also authorized to sentence you in this case, or committing that offense while under supervision in this case, to additional period of 1 year. Period of time left on that 2 years of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the case. All right, so anything further with counsel?
Mayor.
All right, your man back to custody. Charles Miller. All right, we have 2 cases here. Case number 21 CR 120, 21 CR 188, both State of Ohio versus Charles E. Miller Jr. Appearing on behalf of the state is the prosecuting attorney Collins. Appearing on behalf of the defendant is attorney Catherine Hacker. And are you Charles E. Miller Jr.?
Yes, Your Honor.
All right, in case number 21 CR 120, defendant is charged with aggravated possession of methamphetamine and 53 felony, and 21 CR 188 is charged with failure to appear, a 4th degree felony. Matter is set today for plea. I have been presented Mr. Miller with two plea agreements. One in each case, these are, I believe, 3 pages long. On page 3, there's our signature line is about a third way down at 120. It says your sentence is an end of 2 miles fairly right where that looks like Mr. Charles Miller. And then in case number 188, it's same thing, Charles Miller. Did you sign these 2 agreements we're looking at?
Yes, Your Honor.
When did you sign them, Mr. Miller?
Yesterday, Your Honor.
All right, did you go over these with your attorney and have her explain everything to you, or answer any questions you had before you signed them?
Yes, Your Honor.
When you sign these agreements, did you understand that it's an agreement to plead guilty in each case, and that means it will be trial, the next step will be a sentencing hearing?
Yes, Your Honor.
And do you feel that you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And do you feel that you could pressure or rush in any way to do this?
No, Your Honor.
And are you entering into the agreement to plead guilty in each of these cases voluntarily?
Yes, Your Honor.
Right now, case number 21-0120 says you're going to plead guilty to the aggravated possession of methamphetamine under 2925.11 with high-rise code for your felony. For the state's understanding the maximum prison term for that could be 12 months, minimum would be 6 if there's prison term imposed. There's a bond available by $2,500 and possible license suspension 6 months to 5 years. Case number 21-0188 says you're going to plead guilty to the single count failure to appear. 2937.99 is the higher rise code of war free felony. State you understand the maximum penalty for that could be 18 months in prison, minimum would be 6 if prison term imposed. You're fined up to $5,000, and in each case, or in the other case, I'm trying to take, there could be license for 6 months to 5 years. All right, you understand that?
Yes, Your Honor.
Now, in the event that you plead guilty to both of these offenses and are sentenced to prison, the sentences will be ordered to serve consecutively, one after the other. So the maximum in the 20 case, 12 months, 188 cases, 18 months. So the total of that is 30 months, and the total of 175 months. You understand that?
Yes, Your Honor.
Other than these 2 charges, you face any felony charge anywhere else?
No, Your Honor.
Are you currently on probation, community control, parole, post-release control, or felony of any restriction?
No, Your Honor.
All right, now, under the law, Mr. Miller, if you're convicted of these offenses and sentenced to prison, in addition to the sentences imposed by the court, once that's completed, the adult parole authority could, at its option, decide that you should be put under post-release control for a period of up to 2 years. They don't have to do it, but they can, but it's up to them. In the event that they do that, that means that you'll be supervised on the terms they set by a parole officer. And if during that period of time, they find that you have failed to comply, they can return to the prison to make you serve an additional period of up to 1/2 of the prison term as a maximum of 9 months for any single violation, total of 1/2 of whatever prison term is imposed for all. So if you committed a felony while under post-release control, then in addition to whatever sentence the judge in new case imposed, that judge could also sentence you for committing that new felony while under post-release control, in this case, to an additional period of 1 year, whatever time that on that period of post-release control is greater. If that occurs, that must be served consecutively to the sentence in the case. You understand that?
Yes, Your Honor.
Now, under the law, I'm not required to put you in prison for these offenses. I can impose, it's called community control, or probation is what most people know to be. And that means you would be supervised on the term set by the court for up to 5 years by probation. If during that period of time probation department doesn't feel non-compliant, they would have to file a written notice of that in court. You would get a copy and be entitled to have a hearing and be represented by an attorney in that hearing. And if the outcome of that was that you failed to comply, then at that time the court would revoke the community control in each case and sentence you to a total of 12 months and 120, 18 months and 188, you're finding a total of $75 and $120. Suspend your license for 6 months to 5 years. You understand all that?
Yes, Your Honor.
All right, now, the charge in 120 alleges that on or about September 19, 2020, in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance. Methamphetamine, violation section 2925.11, so that's the 5th degree felony. Case number 188, that alleges that on or about September 22, 2021, in Highland County, Ohio, you did recklessly fail to appear as required in Highland County Police Court case number 21-0120 after having been released pursuant to ORC 2937.29, released in connection with charge felony. So that's a violation of 137.992. And Mr. Miller, do you understand what it is you've been charged with in each of those cases where the state is alleging you did one or how they alleged you did it?
Yes, Your Honor.
And you understand the penalties for each offense?
Yes, Your Honor.
And have you discussed the nature of the charges, the evidence in each of the cases, the possible legal issues in each case, the possible defense you try to raise at trial in each case, and possible outcome of the trial with your attorney?
Yes, Your Honor.
Are you satisfied with your advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Has anyone threatened you to make you plead guilty here today?
No, Your Honor.
Now, on page 2 of each plea agreement, there's some printing in bold and underlined, and there's been part of it marked out because they're all alternatives. So the one that doesn't apply is marked out in each form. So I will reference and read to you that part of the names in each form. Case number 21-0120, it states the defense shall plead guilty to the indictment. State defense shall only recommend 9 months incarceration consecutive to the sentence imposed in case number 21-0188. Case number 21-0188 says the defendant shall plead guilty to the indictment. State defense shall only recommend 9 months incarceration consecutive to the sentence imposed in case number 21-0120. Now, is that your understanding of the agreement in each case?
Yes, Your Honor.
Does anyone promise you anything other than that in case you plead guilty here today?
No, Your Honor.
Under the law, Mr. Miller, the matter sentence is up to the judge. So even though there's a recommendation from both parties that the sentence should be 9 months in each case consecutive for a total of 18 months, plead guilty, I can sentence you to any of the sentence I think is appropriate between 30 months based on what's been presented to me. Do you understand that?
Yes, Your Honor.
And so do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, Your Honor.
All right, now, you have certain constitutional rights that apply in each of these cases, so as I explained that, they apply in each case, whether I say it or not. First of all, in each case, you have a right to counsel. Ms. Happer was appointed to represent you, not simply work the case out, but provide any defense that we feel to the law that you like to provide. So, besides you don't want to plead guilty in either of these cases, or both, she'll continue to defend you, including a trial in each case if that's what you want. Do you understand that?
Yes, Your Honor.
Now, in each of these cases, you have a right to have a jury trial, in which 12 people will be selected, a group of citizens that are summoned to jury that live in this county. Once the jury was selected, in each case, the evidence will be presented that jury will be instructed on the law. Then, in each case, the jury would have to decide by unanimous verdict. That means that all 12 of the people who are on the jury would have to agree as to a verdict as to each case. Now, if you didn't want to have a jury trial in either or both cases, but you didn't want to plead guilty, you could waive in writing, which means to give up the right to have a jury trial in each or both cases. And in that case, you would have what's called an advanced report trial. That means that the judges will hear the evidence instead of the jury applies law and decides about the state proof the guilt of the charge in each case. You understand that?
Yes, Your Honor.
Right now, in each of these cases, you have a right to prompt witnesses against you, cross-examine with your attorney. What that means is the witness against you have to come into court, that might be you, your attorney, and then we'll ask the question, after the prosecutor then asks the question, your attorney asks the question, that's called cross-examination. The purpose of that would be to try to figure out evidence to help your side of the case in each of the cases. You understand that?
Yes, Your Honor.
In each of these cases, Mr. Miller had the right to use the power of the court, compel the court witnesses to come forward to testify on your behalf in the same state. So if you have witnesses you're uncertain of going to come in voluntarily, your request for which the court will respond to subpoena, and of course those witnesses to come to court and be able to testify if one of you, though they don't want to be here, which is the same way the state's witnesses are required to come to court and testify against you. You understand that?
Yes, Your Honor.
Right, under the Constitution, in each of these cases, you have the privilege of self-determination. Means you cannot be forced to give evidence at any time, including trial. No one can ever make you testify. The prosecutor can, the judge can, it's up to you. And if you decide not to testify in either of both cases, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. In fact, no one's even allowed to talk about it except in one situation, and that is if there's a jury trial and you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Now, in each of these cases, you're presumed innocent to prove guilty by the state of Ohio on every such element of the defense charge. That means that the burden of proof isn't on you to try to show you're not guilty simply because you've been accused in these two cases. In fact, under law, you don't have to present a defense in either case. You can, but it's not required. But whether you do present a defense in either of these cases or not, and proof in each case will remain upon the state of Ohio to prove your guilt and prove beyond a reasonable doubt on every essential element of the offense charge, which is the highest burden group is known under the law. You understand that?
Yes, Your Honor.
Right now, originally entered pleas of not guilty in each of these cases, a plea of not guilty denied the allegations of not committed any crime. That exercise will revoke all the rights that I just described. Now, if you change your plea, from not guilty to guilty, that's a complete opposite of not guilty plea, and that's the allegation that that's a fair crime, that you committed that crime. In that plea, Wage gives up all the rights I've just described for you in each case, except the right to have an attorney. You always have a right to have an attorney no matter what you plead. With that exception, your plea of guilty, Wage gives up your right to have a jury report trial. Wage gives up your right to report the witness against you process your attorney. Wage gives up the right to use the power of the court to tell, of course, witnesses in each case and the court to testify on your behalf in the same state. Wage gives up your guilt against self-incrimination in each case, but to say you're guilty, that's what she finds you guilty. And Wage gives up your presumption of innocence in each case because to say you're guilty, the state's not required to prove you're guilty. Subjects you to being sentenced immediately by the court, which is what appears to be likely in this case. And finally, Wage gives up the right to file an appeal of any alleged violations of the rights you think may have occurred up until this point in the case. Now, should I sentence you to the maximum sentence under the certain circumstances you can file an appeal? That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen, Mr. Miller?
Yes, Your Honor.
And are you entering into these guilty pleas in each case voluntarily?
Yes, Your Honor.
Do you have any questions about the charge in either case?
No, Your Honor.
Do you understand?
Yes, Your Honor.
Do you have any questions about the penalty for either case?
No, Your Honor.
Do you understand those?
Yes, Your Honor.
Any questions about the plea agreement?
No, Your Honor.
Do you understand those?
Yes, Your Honor.
Any questions about the constitutional rights of this claim?
No, Your Honor.
Do you understand them?
Yes, Your Honor.
Any questions about the plea of guilty, what it means, what will happen at the end of that plea here today?
No, Your Honor.
Do you understand that?
Yes, Your Honor.
Is there anything you'd like to speak to Ms. Hapner about before we go any further?
No, Your Honor.
Then is it your decision, Mr. Miller, to withdraw your not guilty plea in each of these cases and plead guilty to the charge in each case?
Yes, Your Honor.
And as to the charge in case number 21 CR 120, which alleges that on or about September 19, 2020, in Huntington, Ohio, you did knowingly obtain, possess, or use against two controlled substances of methamphetamine in violation of section 2925.11 Ohio Vice Code, the charge of aggravated possession of methamphetamine, fifth degree felony, carrying possible prison term 26 to 12 months, and a fine of $2,500 and a possible life suspension of 6 months to 5 years out of plea.
Guilty, Your Honor.
Alright, as to the charge in 21 CR 188, which alleges that on or about September 22, 2021, Huntington, Ohio, you did reference to the bail period required in Huntington County Police Court case number 21 CR 0120, and after having been released pursuant to ORC 2937.29, releases with actual charge of commission of felony, violation section 2937.99, the charge of failure to appear in court degree felony, and possible prison term 26 to 18 months, and $5,000 out of plea.
Guilty, Your Honor.
Alright, thank you. Court finds on this day of the court that will provide all its constitutional rights by knowing itself and voluntary waiver of same, section 11. Pleas are accepted for the five defendants found guilty in each case. The charge set forth therein and the indictment in each case. Alright, court, we'll go ahead and proceed with sentencing before we wet. How long is anything you want to present?
No, Your Honor, did she agree to the 9 months, or were you arguing sentence? I didn't know.
That was,
Okay, then I have nothing further.
okay. Sarah? Obviously, she wasn't paying attention, but that's right, I'm usually ignoring.
I'm not ignoring you.
Okay.
Thank you, Your Honor. We would ask that you comply with the plea agreement. I've known Charles for a long time, and when I was out speaking with him yesterday, he's indicated to me, and I hope he is sincere in this, that he's too old to still be doing these things that a young man does. And I hope he has hit rock bottom, and that this is his opportunity to get straight, get onto a better path. And he's indicated that to me, so I hope that is accurate, and we would ask that you follow the plea agreement, Your Honor.
All right, Mr. Miller, anything you'd like to say?
No, Your Honor.
Okay, well, Miller, looks like this is your third felony. They had a previous, lead control back in 2012, didn't make it, and I ended up in prison back in 2005. Looks like you put on lead control after you had intervention of blue. 2 years later, said you had to make control, and see how it is, so I don't see it, just what I did. In this case, in 120, you, there was a summons issued for you that you wanted to do, and, your indictment was in July of 2021, and, they found you, then you, had problems not reporting on pre-trial supervision, and then you failed to appear for the hearing, and then ended up in another night. So, trying to hide and avoid these types of things hasn't worked out very well for you. But, based upon the agreement, the court's reviewed that, the court gives that as a reasonable, disposition on accepting the recommendation. So it's therefore ordered that in, each of these cases you be and are hereby sentenced to the Correctional Section Center, Edward, Ohio, for a period of 9 months. Those sentences will be served consecutively with one another. Court finds that, first of all, there's been a joint recommendation stipulation that secondly, the 21 CR 188 case was committed while you were awaiting trial on bond in case number 120. Court finds that one, they committed those different courses of conduct and one single sentence is not accurate by restrictions of the offenses, and the warrant is caused by requiring the case to be prosecuted, and sentences that may impose are not disproportionate to the seriousness of the offense. One single prison term is said not accurate reflect the seriousness. And also your history on the demonstrates the second sentences in this. According to the sheriff, you had 17 days of jail time credit. Part of the time that you were in jail, when you were originally arrested, was applied to a sentence from the district court every day. So that's the reason it's not more. All right. Now, on completion of your, there's 0 time for 188 case, all the time goes to the on the case. Now, upon completion of the prison sentence, in this case, the adult parole authority may and their officer place you under post-release control for a period of up to 2 years. If they do, you'll be supervised in the terms they set by a parole officer. If they determine that you fail to comply, they can return you to prison until you serve the entire term ordered by the court for an additional period of up to 9 months for one or more violations. That will also be the cap in this case, since your total sentence is 18 months. However, if you commit a new felony while under post-release control, then in addition to whatever sentence the judge in the new case proposed on you, that judge could also sentence you for committing that offense under post-release control in these cases to an additional period of 1 year, whatever time is left upon the post-release control whichever is greater, and in fact, greater than the second sentence in the case. You're also working at court costs, which judge and grant execution order. If you fail to do that, the court can collect that through various means, including letter and bank accounts where you determines whether assets you may have. That doesn't collect it once you finish your prison term, not while you're in prison, but once you get out, and the court can allow you to do service in this county. To give you credit for each hour you work, in an hourly rate set by the court, each hour you work, reduce your credit by that amount to pay for. There'll be no license suspension in 21 CR 188 or 120. There'll be no fine and non-repairs. All right, is there anything further from council?
Mayor.
Commissioner Manning, Councilman.
Backridge.
You may. All right, Samuel McKee.
Which one, this one?
Yeah, that one.
Alright, we have two cases here involved with the same defendant, case number 21 CR 200 and 21 CR 27. 22 CR 27. The prosecuting attorney and Colin, the Kansas State. We're going to have our trial and our Samuel Key.
Can you hear him okay?
Not barely. Oh, okay, I'm sorry. Are you Samuel McKee?
Yes,
All right.
Your Honor.
All right, so Mr. McKee is charged in 21 CR 200, along with 3 other co-defendants with breaking and entering, and theft. And in case number 22 CR 27, Mr. McKee is charged with failure to appear. Now, this matter was set to Mr. McKee for a sentence or for a plea hearing, and I've been presented with 2 plea forms here, and they each have your name and case number for each case. Says in the 200, you're going to plead guilty to the first count of breaking and entering, and in 22 CR 27, you're going to plead guilty to failure to appear. Each of these agreements are 3 pages, and on page 3, there are signature lines, and there's a sentence that says, I enter this plea voluntarily, and then there's a signature line below, and it looks like Samuel McKee, and what I would call printing as opposed to person. Is that your signature I'm looking at?
Yes, Your Honor.
That's how you sign your name?
Yes, Your Honor.
All right, and when did you sign these agreements, Mr. McKee?
Yesterday.
At the jail?
Yes, Your Honor.
And did you go over these with your attorney and have him explain everything to you before you signed them?
Yes, Your Honor.
And did you understand when you signed these agreements that it meant you were going to plead guilty, there wouldn't be a trial, and the next step in the case would be a sentencing?
Yes, Your Honor.
And did you feel that you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
You haven't been rushed or pressured in any way to doing this?
No, Your Honor.
You're entering in each of these agreements plead guilty voluntarily?
Yes, Your Honor.
All right, now on case number 21 CR 200, says you're going to plead guilty to count 1, which is breaking and entering, under 2911.13a, a 5th degree felony. The states that you understand the maximum prison term for that is between 6 to 12 months, fine of $2,500. And the other 2 counts will be dismissed, or the other count, I should say. Now, in 22 CR 27, says you're going to plead guilty to the single count of failure to appear, under 2937.99, a 4th degree felony. In the states that you understand the maximum prison term for that could be 18 months, the minimum would also be 6. There could be a fine of $5,000. You understand that?
Yes, Your Honor.
Now, Mr. McKee, if you are convicted of both of these offenses and sentenced to prison, those prison terms will be ordered to serve consecutively, meaning one after the other. And so that means a total of possible would be 12 months in the 200 case, 21 CR 200, and 18 months in the 22 CR 27. That's a total of 30 months, possible fine of $7,500 total. You understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony in any jurisdiction?
Facing charges.
Yeah, according to the discovery, I was just looking at it as a charge of possession of handgun by a convicted felon failure to appear as active warrant out of Fleming County. You aware of that?
No.
All right. Well, now you are. So, in the event that you're convicted in this case, sentenced to prison, then Kentucky possibly could come get you and sentence you to prison down there if you're convicted, or in addition, whatever term you serve here. You understand that?
Yes, Your Honor.
Okay. Now, under the law, if you're convicted of these offenses, once you've served the prison term imposed by the court, the adult parole authority may, at their option, decide after you finish the prison term to put you under post-release control supervision for up to 2 years, which means you'll be supervised by a parole officer by terms set by the APA because the court's not involved with that. And if they determine that you have not complied with those conditions, then they can return you to prison, make you serve an extra time of up to 9 months for one violation, but there is a cap or limit of half whatever prison term was ordered by the judge for all violations. But if you commit a new felony while under post-release control, then in addition to whatever sentence the judge in the new case could impose upon you, that judge could also sentence you, in this case, to an additional, or for committing that offense while under supervision in this case, to an additional period of 1 year, whatever time was left on the post-release control, whichever is more. If that occurs, that has to be served consecutively the sentence in the new case. You understand that? Now, I'm not required by law to sentence you to prison for these offenses. I could impose community control, which means that instead of being sent to prison, you would be put under supervision of a probation officer of a term set by the court for a period of up to 5 years. If during that period of time, the probation department felt that you were not complying, they would file a written notice that the court serve a copy on you, and you would have a hearing. You would also be entitled to have an attorney. If the outcome of that hearing was that you failed to comply, then at that time, the court could revoke your community control and then sentence you to prison in the 200 case for 21 CR 200 for 12 months, and in the 22 CR 27 to 18 months, and then fine you a total of $7,500. You understand that?
Yes, sir.
All right. Now, the charge in 21 CR 200 alleges that on or about November 7, 2021, in Highland County, Ohio, you, Brian Lee Van Hoos Jr., Harold J. Kramer, and Selena M. Kinzer did knowingly by force, dealt with deception, trespassing, and unoccupied structure to an empty house at 3853 SR 136 Hillsborough, purpose to commit therein a theft offense as defined under ORC 2913.02A1 or a felony, violation of section 2911.13A. So that's the charge of breaking and entering, fifth degree felony. Now, in the other case, the 22 CR 207 case, that alleges that on or about January 19 of this year, in this county, you recklessly failed to appear as required in the other case after having been released to ORC, pursuant to ORC 2937.29, which is the OR section, and the release was in connection with the charge of commission of felony, violation 2937.99. So that's a failure to appear in the fourth degree felony. Now, Mr. McKee, do you understand what it is you've been charged with in each of those cases, what the state says you did, when, where, and how, and when you did it?
Yes, sir.
Have you discussed the nature of each of those charges, the evidence in each case, the possible legal issues in each case, the possible defenses you try to raise in each case, and the possible outcomes of the trial in each case with your attorney?
Yes.
Are you satisfied with his advice and confidence in this matter?
I didn't hear you.
Are you satisfied with his advice and confidence in this matter?
Yes.
You're satisfied with his representation?
Yes.
Okay. Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any express been made to make you plead guilty here today?
No, Your Honor.
Now, in each case, toward the bottom of page 2, there's several lines that are printed in bold and underlined, and then there's some that have been marked out because they were different options. And so I'm going to read the ones that have not been marked out. In case number 21 CR 200, it reads, defendant shall under plea of guilty to count 1. State will dismiss the remaining count. State defense shall not recommend 9 months incarceration. Defendant shall cooperate fully in prosecution of defendants. Co-defendants. Case number 22 CR 27, the agreement reads, defendant shall under plea of guilty to the indictment. State defense shall not recommend 9 months incarceration consecutive to the sentence imposed in case number 21 CR 200. Now, is that your understanding of the agreement?
You already said to me? Yes.
Okay. Has anyone promised you anything other than that to get you to plead guilty?
Has anybody promised you anything other than what we talked about, that the agreement is?
No. Okay. Now, Mr. McKee, under the law, the matter of sentence is up to the judge, not to the parties. So even though there's an agreement between the state and you that the sentence should be 9 months in each count consecutive, if you plead guilty, I'm not required to follow that recommendation. I could impose any sentence between 6 and 30 months, plus fine you up to $7,500. Do you understand that?
Yes, sir.
Okay. Do you hold any license or certificate from any state governmental agency that regulates any kind of an occupational profession?
You have some Can you do any kind of work that requires you to be licensed?
Like a barber or vet tech or something like that. Okay. Now, Mr. McKee, you have certain rights you have to understand before I can accept a guilty plea. First of all, you have a right to counsel. Mr. Armin Trout was appointed to represent you. That wasn't simply to work the case out. But to provide any defense could be available to you in either case that you would like me to provide. And so if you decide you do not want to plead guilty in either or both cases, he will continue to defend you, represent you, including a trial if that's what you want. You understand that?
Yes, Your Honor.
Now, the rights I'm going to explain to you apply in each case. So if I don't say that, they do apply in each case. So, first of all, in each case, you have a right to have a jury trial, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial day. Now, after 12 people are selected, the evidence will be presented in each of the cases, and the jury will be instructed on the law. Then that jury will decide by unanimous verdict, meaning all 12 have to agree in each case, whether the state proves your guilt. Now, if you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing. And what that means is give up your right to have a jury trial in either or both cases. And in that case, you would have a bench or court trial in that case or cases. And what that means is instead of having a jury hear the evidence and make the decision, the judge would be the one who would hear the evidence and apply the law and decide whether or not the state proves your guilt. You understand that?
Yes, sir.
Now, under the Constitution, Mr. McKee, you have a right to confront the witnesses against you in each of these cases, and to have your attorney cross-examine them in open court. What that means is that the witnesses in each case would have to come in court, testify in front of you and your attorney and anyone else who may be present in the courtroom. After the prosecutor is done asking questions, your attorney can ask questions. That's called cross-examination, and that is for the purpose of trying to bring out evidence that might help your side of the case in either or both cases. You understand that?
Yes, sir.
Right now, in each of these cases, Mr. McKee, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain going to come in voluntarily, it's your request for issues a court order, that's called subpoena. And that forces those witnesses to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination in each of these cases. What that means is that you cannot be forced to give evidence or to testify in either case. No one can make you testify. The prosecutor can't, the judge can't. It is up to you. And if you decide you're not going to testify in either or both cases, the fact that you did not testify will not be used against you in any way by any person at any time. And no one's even allowed to talk about it with one exception. That is, if there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they can't consider it for any purpose. You understand that?
Yes, sir.
Now, in each of these cases, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof isn't on you to try to prove you're not guilty of these charges just because you've been indicted. In fact, under the law, you don't have to present any evidence in your defense at either trial. You can, but you're not required to. Whether you do or not, the burden of proof will remain upon the state of Ohio, the prosecutor, prove your guilt by proof beyond reasonable doubt in each of these cases, which is the highest burden of proof that is known by the law. You understand that?
Yes, sir.
All right, now, Mr. McKee, originally you pled not, not guilty in each of these cases. The not guilty plea denies the allegation in each case, denies that you committed any crime, and that exercises or invokes all the rights I just described for you in each case. If you change your plea from not guilty to guilty in these cases, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in each case that you're pleading guilty to, admits that it's a crime, and that you committed that crime. That plea waives gives up all the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty in each case would waive give up the right to have a jury or court trial, The waiver give up the right to confront the witness against you and cross-examine through your attorney. The waiver give up the right to use the power of the court to compel force witnesses to be in court to testify for you, just like the state. The waiver give up the privilege of self-incrimination because if you say you're guilty, then that's what you find you guilty in that case. And a waiver gives up the right to require the state to prove your guilt in each case, because if you plead guilty, then the state's not required to prove your guilt. Plea of guilty waives gives up your right to file an appeal and any alleged violations you think your rights may have occurred up to this point in that case. And finally, it subjects you to being sentenced immediately by the court, which is likely what's going to happen. Now, do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen, Mr. McKee?
Yes, Your Honor.
Now, do you have any questions about the charge in either case that is proposed you plead guilty to?
Any questions about the charges?
And what they take months?
What you're charged?
No, in other words, do you understand the charge and the possible penalty in each case?
Yes, yes, Your
Okay.
Honor.
And do you have any questions about the plea agreement? In either case?
No, Your Honor.
You understand?
Yes, Your Honor.
You have any questions about any of the constitutional rights I've explained here today? You understand them?
Yes, Your Honor.
Okay. You have any questions about the plea of guilty, what it means, or what's going to happen if you enter that plea?
None, Your Honor.
Okay, you understand?
Yes, Your Honor. Yes, Your Honor.
And, forget to ask you, but you are a U.S. citizen?
Yes, Your Honor.
Okay. Now, is there anything else you'd like to speak to your attorney about before we go any further?
None, Your Honor.
Do you have any questions about anything that's happened that I've explained to you here this morning?
What's that?
Yeah, if there are any questions you'd like to ask me, now's the time to.
Yes, you said I had a case in Kentucky, how did this solve that?
I don't know, you'll have to contact, somebody down there that represents you. We can't do anything about that up here, it's a Kentucky case. Yeah, I just know what's on the paperwork that's in front of me.
Yeah.
So if they want you, they'll have to come get you, or whenever you get out of prison, go down and load it up there, I guess. Yeah.
Okay, all right.
Yeah. Any other questions then?
No, Your Honor.
Then is it your decision to withdraw your not guilty plea, plead guilty to the charges in each of these two cases, pursuant to the plea agreements that we've just gone over?
Yes, Your Honor.
All right, then as to the first case, Mr. McKee, 21 CR 200, that alleges that on or about November 7, 2021, County, Ohio, that you, Brian Lee Van Hoos Jr., Harold J. Kramer, and Solana M. Kinzer did knowingly by force, stealth, deception, trespass, and an unoccupied structure to let an empty house at 3853 State Route 136 Hillsborough, with purpose to commit therein a theft offense as defined in ORC section 2913.0281 or felony, violation section 2911.13A, the Higher Revised Code, the charge of breaking and entering, the 5th degree felony, carrying possible prison term 26 to 12 months, and a fine of $2,500. How do you plead?
Guilty.
Right now, as to the charge in case number 22 CR 27, it alleges that on or about January 19, 2022 in Highland County, Ohio, you did recklessly fail to appear as required in Highland County Common Pleas Court case number 21 CR 200 after having been released pursuant to ORC 2937.29 and released was in connection with the charge of commission of felony. Violation section 2937.99 of the High Revised Code, failure to appear, 4th degree felony, carrying possible prison term 26 and 18 months and a fine of $5,000. How do you plead?
Guilty.
All right, thank you. The court finds that on this day of the court, defendant was advised of all his constitutional rights, made an own intelligent, voluntary waiver of the same pursuant to criminal 11. Please accept it in order filed. Defendant's found guilty of count 1 and 21 CR 200, passed to dismiss. And then the accountability of the single count 22 CR 27. All right, given the recommendation of the parties and the court's review of the discovery, compliance, the court will go ahead and proceed with sentencing, work with. Just, Collins, anything on behalf of the state?
We ask the court to follow the agreed sentence, or the agreed recommended sentence. We note that, while the actual victim in this case, Mrs. Serber, is not in good health, but I did speak with her son Kevin, and he agreed with this plea agreement. And there is no resolution.
All right, Mr. Myercott.
I'm going to ask the court to follow the plea agreement, send Sam to 9 months on each count. Sam's cooperated with me there, tried to duck what he did do, that he didn't appear in or he was supposed to. We'd ask the court to call him.
All right, Mr. McKee, anything you would like to say?
I just, when I get to prison, I just want to make sure you put on there, and I do like to work on the outside. I mean, I love to work. That's all I ask, you know.
Well, I can't, control what they do with you, that's, let the prison make that decision, but, yeah, I'm sure they'll take that into consideration. Gee, sure. Prison term here in Ohio looks like back in 2013, Lotus assault. And then also, for in 2001, for, cases out of Cleveland County, Kentucky, that correct, 2 times in prison? Once in Ohio, once in Kentucky?
Yes, Your Honor.
That's all the numbers you have? Okay. Well, that hadn't been really offensive than others in between here. So. All right, what's the order then, the judgment of the court that you be, and are hereby sentenced in each case to a period of 9 months at the correctional reception center in Ohio. These sentences are served consecutively to one another. First of all, parties have stipulated that the sentence. Secondly, court finds that the offensive case number 22 CR 27 committed while he was waiting trial and released on bond 21 CR 200. The courses, the offenses are part of 2 different courses of conduct, and the court finds that one single term not accurate that harm has been caused by the conduct requiring prosecution in 2 cases, and the sentence is not disproportionate to the seriousness of the crime. One single prison term not accurate reflect that seriousness. And also the defendant's history of criminal conduct indicates that it's necessary to protect the public from future harm. According to the sheriff, you were incarcerated from March 22nd of this year till today. Is that right, Mr. D? 28 days?
Yes, Your Honor.
All right. So you'll be given credit for that in case number 21 CR 200. There'll be no time. There is no time credit 22 CR 227. Now, upon completion of these prison terms, Mr. McKee, the adult parole authority may, at their option, place you under close release control. They don't have to, but they can. And if they do, they'll be supervised on the terms they set for up to 2 years by parole officer. If they determine that you have failed to comply, they can return you to prison, either they serve the entire term set by the court, or an additional period of up to, in this case, 9 months for 1 or more violations. That's the cap. But if you commit a new felony while under close release control supervision, then an additional letter of sentence to judge in that new case imposed upon you. The judge could also sentence you in this case to an additional period of 1 year, whatever time is left on the close release control, whichever is more or greater. If that occurs, that has to be served consecutive sentence in the new case. You're also ordered to pay the court costs, and if you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then on completion of your prison term, not while you're in prison, but once you get done, the court can order you to do your service in this county and give you credit for each hour you work in an hourly rate set, and for each hour you work, reduce your judge by that amount. All right, is there anything further with counsel?
They are.
They are.
That you remain back to custody, Mr. Keith.
That's what Your Honor.
Okay. Brock Vernon. Case number 22-46, State of Ohio versus Brock, Nicholas Vernon, appearing on behalf of the state, prosecuting Attorney Collins, appearing on behalf of defendants, Attorney William Armentrout. And are you, Brock, Nicholas Vernon?
Yes, Your Honor.
All right, Mr. Vernon is charged with escape and assault on a police officer. Matter was set today for a plea. I have been presented with a form, Mr. Vernon, which indicates you're going to withdraw your not guilty plea, plead guilty to both charges. Now, this is a 3-page form, and the prosecutor prepared. On page 3, there's a signature line about halfway, not quite halfway down the page. On page 3, right above that, there's a sentence that says, "I enter this plea voluntarily." Right below that, there's a signature, which I have to admit is probably as sloppy as mine. But is that your signature I'm looking at here?
Yes, Your Honor.
All right. And when did you sign this agreement, Mr. Vernon?
Yes, Your Honor.
And when you signed it, did Mr. Armentrout explain everything to you, go over with you before you signed it?
Yes, Your Honor.
Did you understand when you signed this agreement, Mr. Vernon, that it was an agreement to plead guilty, which means there won't be a trial, and that's that in the case of the sentencing hearing?
Yes, Your Honor.
Do you feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
And are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
Now, the agreement states that you're going to plead guilty to count 1 and count 2. Count 1 being escape on 2921.34A1, a third-degree felony. Count 2 being assault on a peace officer under 2903.13A, a fourth-degree felony. Further states that you understand that with regard to count 1, the maximum punishment could be 36 months in prison. It could be a term between 9 and 36 months under the age provided by law. Goes from 9 to 12, and every 6 months up to 36 months, and a fine of up to $10,000. Then there's count 2. There's a possible maximum prison term of 18 months, minimum 6, and any number between those 2. Any fine of $5,000. And if these sentences were ordered to be served consecutively, one after the other, that means that there could be a maximum penalty of 54 months in prison and a maximum fine of $15,000. You understand all that?
Yes, Your Honor.
Mr. Vernon, are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony from any jurisdiction?
He does have he's taking care of it in Fayette County, but it's still sentencing.
Oh, okay. So you're waiting sentencing up there?
Yes, sir.
All right. So if you're sentenced to prison from this case, in this court, and from that court, and that sentence up there, they could maybe run consecutive whatever sentence as opposed to this case. You understand that?
Yes.
Okay. You're not under probation, community control, parole, or post-release control for a felony.
Yes.
Yes. Post-release control. Yes.
Post-release control?
Yes, Your Honor.
It was filed on March the 2nd, Judge.
He's aware of it, Your Honor. Has been since.
Yeah, okay. Let me find that here. Oh, there it is. All right, so on March the 2nd, okay, this is dated March the 1st. That time, we had 738 days remaining from a case from Fayette County. Okay, so that's the case you're talking about. It's not a new charge, or is there another one?
No.
Okay, there's another one. Okay. So, in PRC here, 738 days as of March the 1st. So, today is the 20th of April. So, you have 34 days of credit in March. And today is 20, so that's 50. So, 738 minus 50 is 688 days. So if you are convicted in this case and sent to prison, that the court could and will sentence you to the 688 days consecutive, because under the law, court can impose either 1 year or whatever time is left on the post-release control, whichever is greater or more. In this case, 688 is more than 1 year. So that would be the order to be served consecutively to any sentence in this for these two offenses. You understand that?
Yes.
Okay. And then if Fayette County sentences you to prison as well, your sentences up there could be added on to that sentence, to this sentence. You understand that?
Yes, sir.
All right. under the law, if you are sentenced to prison and serve a prison term, and once you plead, let's see, escape is considered domestic violence.
Yes.
Okay.
I've had to research that before for what the disability action.
Yeah. Well, what that means is that because under the law, count one is considered escape or domestic violence. Two is as well, but it's a fourth degree felony, so that doesn't apply here. What that means is that when you complete the prison term imposed by the court, you will be in a post-release control supervision again. And that will be a mandatory period of at least a year, up to 3 years, at the discretion of the court. So it will have to be at least a year. It could make it as much as 3 years. It's all up to them. And what that means is you're supervised in the terms they said, as you know, by a parole officer. And if during the time you're under post-release control supervision, they determine that you have failed to comply, they could return you to prison as a sanction to make you serve additional periods. Up to 9 months for one violation, up to a maximum of half of whatever prison term for imposed for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new case could impose a claim, the judge could also sentence you in this case for committing that offense while under post-release control in this case to an additional period of 1 year, whatever time to be left on the period of post-release control, whichever is greater. That occurs, that must be served consecutively to the sentence in the new case. You understand that?
Yes, Your Honor.
Right now, under the law, these are not mandatory prison offenses. The court could, if it chose to do so, put you in control probation for a period of up to 5 years under terms set by the court. You'd be supervised by a probation officer, and during that period of time, the probation department felt you were non-compliant. They would file a written notice at the court. There would be a hearing after you were served with a copy of it. And if the outcome of that hearing was that you failed to comply, then at that time, the court could revoke your community control, then sentence you to 54 months total and fine you $15,000. You understand that?
Yes, Your Honor.
All right, now, in count one, it's alleged that on or about January 18, 2022, in Pine County, Ohio, that you knowing you were under detention or being referenced in that regard, did purposely break or attempt to break detention, and the said Brock Nicholas Burns was being held in connection to a felony of 4th degree with a post-release control violation for assault of a police officer in violation of RC 29313A. Bay County Common Police Court case number CRI 2018-0469. He is in violation of 2921.34A1 of the Ohio Vice Code. So that's a charge of escape with a sentence of between 9 and 36 months under the levels stated in the law, and a fine of $10,000. Count two, alleged on or about January 18, 2022 in Huntington County, Ohio. You did knowingly cause or attempt to cause physical harm or control of Mark Hamilton, peace officer, as defined in ORC section 2935.01 of the mission duties. Violation section 29.3.13A of the Ohio Vice Code. So that's in charge of assault peace officer. 4th degree felony, possible prison term of 6 to 18 months. Mr. Vernon, do you understand what it is you're charged in each of these cases? What the state says you did, when or how they alleged you did it in each count?
Yes, Your Honor.
And have you discussed the nature of the charges, the evidence in the case, possible legal issues in the case, possible offenses in preparation for trial, possible outcome of the trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to make you plead guilty here today?
No, Your Honor.
Now, there are 3 lines, not quite 3 full lines, printed underlined on page 2, near the bottom of the page, read as follows. Defendant will enter plead guilty to the indictment. State convention went recommend 9 months in count 1, consecutive 9 months in count 2, consecutive to time remaining at post-release control. That's your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that you should plead guilty here today?
No, Your Honor.
Under the law, Mr. Vernon, the matter of sentence is up to the judge, not the parties. And so even though both parties are recommending the sentence be 9 months consecutive, each case for 18 months, if you plead guilty, you're not required to file that recommendation. I can sentence you to any amount of time between 9 and months and 54 months, the last day is broke. You understand that? Now, you hold any license or certificate from any state agency that regulates any occupation, trade, or profession? Now, you have certain rights, you must understand, for to accept a plea of guilty from you, Mr. Vernon. First, you have a right to have an attorney. Mr. Armstrong is appointed to represent you, and that's not simply to work the case out, but to provide any defense that may be available to you under the law which you wish to provide. So, if you decide you don't want to plead guilty to either of these charges, which you'd rather defend against them, guilty to continue to represent you, including a trial, that's what you will have. You understand that?
Yes, sir.
Right, under the Constitution, you have a right to have a jury trial in these two charges in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty on the trial date. After they are selected, that jury will hear the evidence and be instructed on the law. And then they would have to decide on the unanimous verdict between all 12 of the members of the jury would have to agree on whether the state proved for guilt or either of the charges. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive the right, which means give up the right to have a jury trial. And in that case, you would have what's called a court or bench trial. What that means is that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved for guilt. You understand that?
Yes, sir.
Right now, under the Constitution, you have a right to confront witnesses against you and cross-examine them through your attorney. So what that means is witnesses against you have to come in court to testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's the whole cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Vernon, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So, if you have witnesses you're not certain going to be able to come in voluntarily, the jury requests court issues court orders called a subpoena. That forces them to keep. Could you keep it down back there so they don't want to be put in jail for contempt? I don't know how you could possibly be that sleepy. You had nothing to do in jail but sleep, so don't yawn again. I have put people in jail before, disrupting the court while yawn. It's just plain rude. All right, now, I believe I was explaining to you that you have the right to use the power of the court to compel or force witnesses to come forward and be able to testify for you, just like the state. So what that means is if you have witnesses you're uncertain to come in voluntarily, your request is court issues a court order, it's called a subpoena. And that forces those witnesses to come to court and be able to testify even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. You understand that?
Yes, sir.
All right, under the Constitution, you have approach against self-incrimination, Mr. Vernon, which means that you are not required to offer evidence to testify and cannot be compelled to do so any time in this case. So no one there makes a testify. The prosecutor can, the judge can, you make a decision to decide not to testify. The fact that you did not testify cannot be used against you in any way, any person, at any time. No one's even going to comment about it, except in one situation, that is if there's a jury trial, you don't testify. Judge instructs the jury that because that's your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
And under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is this, that you're not required to try to prove you're not guilty simply because you're accused. In fact, under the law, you're not required to present any evidence of your defense at all. You may, but you're not required to. Whether you do or not, burden of proof remains on the state to prove your guilt by proving beyond reasonable doubt in every essential element of each of these offenses. And that's the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right, Mr. Vernon originally entered a plea of not guilty plea denied the allegation that the indictment might have committed a crime, and exercised or invoked all the rights that have been prescribed for him. Now, if you change your plea from not guilty to guilty to these two charges, that is the complete opposite of not guilty. Guilty plea admits the allegation in the indictment, each count, admits that they constitute a crime, that you committed those crimes, and that plea waives gives up all the rights that I've just described for you today, except the right to have an attorney. Because you always have a right to have an attorney, no matter what you plead. With that exception, plea of guilty, wage gives up your right to have a jury or court trial. Wage gives up your right to confront witness an issue, cross-examine through attorney. Wage gives up your right to use power of court, power of court witness in court to testify for you, the same for the state. Wage gives up your privilege of self-incrimination because you're saying you're guilty, that's what she's finding you guilty. Wage gives up your presumption of innocence because you say you're guilty, the state's not required to prove that you're guilty. It also subjects you to being sentenced immediately by the court, which is what's likely to happen here. And finally, a wage gives up any right to file an appeal, which you think you may have at this point in the case. Now, if I should sentence you to maximum sentence, or in other certain circumstances you file an appeal, that would have to be filed within 30 days of your sentencing after being filed. You understand all that?
Yes, sir.
Mr. Burnham, are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the charge or the possible penalty?
No, sir.
You understand?
Yes, sir.
You understand that the conviction of this case carries a time CRC of 88 days.
Yes, sir.
All right. Do you have any questions about the plea agreement?
No, sir.
You understand?
Yes, sir.
Any questions about the constitutional rights of the claim?
No, sir.
Understand those? Have any questions about the plea of guilty, what it means, what will happen if you enter that plea here this morning?
Yes, sir.
You understand?
Yes, sir.
Does anybody speak to Mr. Armstrong about before we go any further?
No, sir.
Have any questions about anything that we've talked about here this morning?
No, sir.
All right, then, Mr. Burns, it's your decision to withdraw your not guilty plea and plead guilty to Local County indictment for social terms agreement from this one over.
Yes, sir.
And you're doing that voluntarily.
Yes, sir.
Then as to the charge of count one, which reads that on or about January 18, 2022, in Manhattan, Ohio, that you, knowing you were under detention or being reckless in that regard, the purpose of great intent to break the detention, and that you will be held in connection to a felony of fourth degree with police control violation or assault of a police officer in violation of RC 193.13A, Fayette County Conflict Court Case Number CRI 2018-0469. In violation of section 2921.34A1, the charge of escape, a third degree felony, carrying possible prison term between 9 and 36 months in increments divided by law, upon $10,000, have you plead? As to count two, the alleged on or about January 18, 2022, in Manhattan, Ohio, you didn't knowingly cause or attempt to cause physical harm to Mark Hamilton, a peace officer defined in ORC section 2935.01, while in the commission of his official duties in violation of 2903.13A, charged with assault of a peace officer, a fourth degree felony, carrying possible prison term between 6 and 18 months, fined $5,000, adding to the all right, thank you. The court finds that this day of the court to provide all the constitutional rights, maybe one of those voluntary waiver of the same percent of 11, please accept or file, and it's not really with each count and indictment set forth therein. The court will go ahead and proceed with sentencing based on stipulation parties and all the circumstances said in this case that's the record. I have reviewed take a look quickly at the discovery. All right, Ms. Collins, on behalf of the state.
Your Honor, we ask the court to follow the joint recommendation as well as for the PRC times left remaining, and would note that Nicole Hamilton approved this agreement. Thank you.
Okay.
Your Honor, I ask the court to follow the agreement. I think the sentences that's recommended by the state are appropriate in this matter, and as the court's aware, we're going to suffer the additional penalty of almost 2 years for the PRC violation. It's going to bring the total to 3.5 years or something like that. So we'd ask the court to follow.
All right, Mr. Vernon, anything you'd like to say?
There you go.
All right, the court will note that you had previous conviction for assault of a police officer, as well as danger to children, Fayette County. And then there's also that additional pending felony. And these are very serious matters. Assault of a police officer haven't happened before, so it's not a good sign for your future. You're going to need to learn to understand that the officers have certain authority. You don't like to tell them. You just need to listen and do what they tell you and then deal with it afterwards. If something's not never ends well with a guy who fights a police officer. So it's the judgment order of the court that has to, count one, escape, which should be sentenced to a term of 9 months in the correctional center of Ohio, and count two, that should be sentenced to a period of 9 months, also in the correctional center of Ohio. Those are the terms that will be served consecutively, one after the other. Now, according to this, the sheriff has you coming into jail on the 31st of January, until today, which is 17 days. You agreed to, I believe, from the 18th to the 31st.
Yes, sir.
So that would be an additional 13 days. So that would be a total of 91 days of jail time, correct? Yeah. You're also ordered to serve the balance of your post-release control time, which is calculated for based on the notice filed on March 1st, or March 2nd, or date of March 1st, 688 days. And so we serve consecutively as well. Now, on completion of a prison term, it is mandatory that you be put under post-release control for a period of at least 1 year and up to 3 years. So count 1, count 4, it's up to 2 years, maybe not optional, but you can also be ordered on count 1 for 1 to 3 years, as determined by the APA. That means is will be supervised by a parole officer at the term set by the APA. They determine that you have to comply with those conditions, they prepare you to prison, they can serve additional period of up to 9 months for one violation up to maximum half of the prison term for all violations. But if you do felony, just like what's happened here, then additional sentence a judge in that new case imposed upon you. For that offense, that judge would also sentence you for committing that offense while under post-release control in this case. An additional period of 1 year where time left on that post-release control, whichever is greater. That occurs, that will be served consecutively since in the case. Also, order paid court costs, which judge can grant execution. Now, if you don't do that, then on completion of your prison term, not while you're in prison, the court will give you control of your service and give you credit for each hour you work and how to arrange that. For each hour you work, you should justify that amount until paid. All right, is there anything further, counsel? All right, sure, get back to custody. Come around, you know, we're going to have a Zoom hearing. We'll have Zoom this afternoon. We're going to need to have a meeting about that.
We actually have the IT guy there, it's supposed to be going on right now.
Okay. Well, we're not back online by, let's say, 12:30. All right, give us a call, let us know so we can let the terms down.
I'll blast and they get back to you.
All right, thank you.
I ain't going to get it.
What do you want?
Thank you.
I don't have anything to offer from my